every promise and every set of promises forming consideration for each other is an agreement. In whatever the manner that prescribed in the contract, if they fulfills all those conditions, then it will be called as actual performance and the contract comes to an end. If any party dies, then they can discharge the contract because only one party cannot continue with the contract. There should be two parties. If any party dies, then the contract can be discharged. Hello everyone, I'm Arun Kumar, lecturer in Department of Commerce and Management, Vidhyaashram First Grade College, the Temple of Excellence, MYSURU. Dear students, welcome to this new session, that is session 4 on unit number 1. The topic is Indian Contract Act 1872. So in the earlier sessions, we discussed about what is contract, what is free consent, what is agreement, what is offer, what is acceptance, essentials of valid contract, what is consideration, essentials of considerations, and also we discussed types of contracts. So in this particular session, dear students, we are going to know the difference between the agreement and contract and also about the discharge of contract. So firstly, we are going to discuss about the distinction between an agreement and a contract. So what is the difference between these two, agreement and contract? So some of you may think agreement and contract both are same. No, it is not same. So agreement is different and contract is different. But agreement is the basic need to get into a contract. Okay, agreement is the basic need to get into a contract, but contract is happens only after the agreement. Okay, so we have some differences between these two, agreement as well as on word contract. So they might ask this question in your exam for 5 marks or for 10 marks. So this is a very important topic where they might ask this question in the exam for 5 marks or for 10 marks. So if you look into the definition, in definition only you will get to know the difference between agreement and contract. So what agreement says? So what is the definition of agreement? So every promise and every set of promises forming consideration for each other is an agreement. Yes, every promise and every set of promises forming consideration for each other is an agreement. That means if two parties comes together and if it agrees to get into an agreement for some consideration by promising some consideration, that is called agreement. Okay, one party will be promising the another party for some consideration, that is called agreement. So two parties comes together and every set of promises forming consideration is called agreement. So what is the definition of contract? An agreement enforceable by law is a contract. An agreement enforceable by law is a contract. Agreement is nothing but two people coming together and they will be going forward with the promises made together and for some consideration is called agreement. When that agreement is enforceable by law, then that is called contract. That means, for example, if you are taking a house for lease, so what you will do, you will take a lease paper. Okay, you will take a stamp paper and on that you will write everything for I am paying 5 lakh rupees for 3 years of lease, this, that and all conditions you will write and you will sign it, you as well as the person who is leasing the property. Okay, so both the parties signed. That is an agreement. Both the parties signed and they took it to the register office and they registered it under the law. Then it is called contract. So if you sign that, just it's an agreement. If it is registered by the registered office, then it is a contract. That is called enforceable by law. If any agreement is enforceable by law, that is called contract. Next difference is about creation. So an agreement is created by acceptance of an offer. Yes, if a person is accepting the offer, accepting the offer, then it is called an agreement. Finished. I'll offer something, okay, I'll offer something, let us say, I'll offer to sell my scooter, opposite party, he accept it, then the agreement will create. The agreement will create between the two parties. Here in contract, agreement and its enforceability together create a contract. Yes, agreement and its enforceability. If it is enforceable by law, then it creates a contract. That is the difference between agreement and contract. Next, legal rights and obligations. Next thing is legal rights and obligation. Under agreement, an agreement may not create legal rights. An agreement may not create legal rights and obligations of the parties. Yes, it's just an agreement. It is not enforced by law. Okay, the agreement is not enforced by law. That is why both the parties who is offering and who is accepting, both the parties will not be having the rights under the agreement. But if it comes to contract, okay, in contract, a contract creates legal rights and obligation between the parties. Yes, if the agreement is enforced by law, it is called contracts. Then a contract will be giving the rights and obligation for both the parties. For both the parties. Who are the parties? The person who is offering and the person who is accepting. Next, necessity. So no contract is required to make an agreement. Yes, the contract will be created only after the agreement. So at the time of agreement, no contract is needed, right? At the time of agreement, no contract is needed. But under contract, valid agreement is necessary for making a contract. Yes, a valid agreement is necessary for making a contract. What is this valid? Yes, all the criteria should be fulfilled while you are getting into the agreement. Then only you can call that agreement into a contract. If you want to get into contract, you are supposed to go with the valid agreement. Legally binding. So an agreement is not a concluding or legally binding contract. Yes, an agreement is not a concluding and legally binding contract. So here, just with the agreement, you can't, file a case. It is not valid. Okay. If it is a contract, yes, obviously that will be having a kind of power. Okay. So in contract, a contract is a concluding or legally binding on the parties. Yes. Here in contract, each and everything will be prescribed and it is enforceable by law. Okay. It comes under the law. That agreement comes under the law. So then obviously they can go legally for whatever the cause they want. Next, concept. Okay. Agreement is a wider concept and includes contracts. Yes. Agreement is a wider concept and includes contracts. That means they can get into any kind of agreements. There is no issue. Okay, they can get into any kind of agreements. There is no issue. But under contract, contract is a narrow concept and it is only a specific of agreement. Yes. Here, contract is a narrow concept. That means if all the agreements related, the things are correct, if everything is followed properly, then only they can get into a contract. So these are the difference between the agreement and contracts. They might ask this question in the main exam for 5 marks or for 10 marks. So please, note down this and try to make out the difference between these two concepts. Next, discharge of contract. Discharge of contract. What is this discharge of contract? We can say end of contract. So when we can end the contract? In what situations we can end the contract? So in many situations we can end the contract and we can start a new contract. Okay. So discharge of contract. When the rights and obligations arising out of the contract are extinguished, the contract is said to be discharged or terminated. Yes, here when the rights and obligations arising out of the contract, rights and obligations arising out of the contract, So rights and duties arises out of the contract. Then you can end the contract, or you can discharge the contract, or you can terminate the contract. See, if everything goes on according to the contract, then well and good. If something is not according to the contract, then you can discharge or terminate the contract. A contract may be discharged by any of the following ways. By any of the following ways. Yes. In case, in these kind of situations, if the contract is not going good, you can discharge your contract, you can terminate, you can end your contract. The situations like by performance, okay. Next, by mutual consent or agreement, by subsequent or supervening impossibilities or illegalities, by lapse of time, by operation of law, and the breach of contract. So in these many situations, you can discharge the contract. So we look into each and every situation in depth. The first one is discharge by performance. So what is this discharge by performance? Performance of a contract is the most popular manner of discharge of a contract. Yes, performance of a contract is the most popular manner of discharge of contract. Yes, in so many situations, based upon the performance of the parties, the contract will be discharged or terminated. The performance may be either actual performance or attempted performance. So here, actual performance. So what is actual performance? When each party fulfills its obligation, each party fulfills its obligations arising out of the contract within the time and in a manner prescribed. It is called the actual performance, and the contract comes to an end. Yes, when both the parties fulfills its obligations arising out of the contract. Okay, if both the parties fulfills the conditions arising out of the contract within the time and in a manner prescribed, in whatever the manner they prescribed in the contract, if they fulfills all those conditions, then it will be called as actual performance and the contract comes to an end. What is this attempted performance? Attempted performance is nothing but when the promisor offers to perform his obligations but is unable to do so because the promisee does not accept the performance. It is called attempted performance or tender. Thus, tender is not actual performance, but it is only an offer to perform the obligation under the contract. A valid tender of performance is equivalent to performance. So here what the promisor will do? The promisor try to fulfills, okay na, the offers, whatever he offered to the promisee. If promisee accepts it, okay, when promisor proposes the offer and if promisee accepts the offer, then it is a actual performance. In case if the promisee, okay, if the promisee is not ready to accept, okay, then it is not a valid and it is called as attempted performance. So here you can see promisor offers to perform his obligation but unable to do so because the promisee does not accept it. So as a promisor, he tries to perform his duty. Okay, if whatever the duty performed by the promisor, if it is accepted by the promisee, then it's fine. If it is not accepted, then it is called attempted performance. Okay. Next, discharge by mutual consent or agreement. A contract is created by means of an agreement. It may also be discharged by another agreement between the same parties. Yes, a contract is created by means of an agreement. Okay, it can be discharged by another agreement between the same parties. So one contract is already made. So to discharge that contract, we are going to get into the another contract. Okay, we are already in one contract. So based on that, we are creating one more contract. At that time, we can discharge the previous contract. Notations, alterations, rescissions, remission, where. That means in these kind of situations, if something alteration is needed, if something notations are missing, so at that time of situation, we are already, in a particular agreement, we are already in a particular contract. If some changes is required, if some changes is required in that contract, what we will do, just we open one more contract, just we get into one more contract and we discharge the earlier contract. That is called discharge by mutual consent or agreement. Next, discharge by lapse of time. Yes, in case if the time is already over, okay, you created a contract for 1 year, so 1 year of time duration is completed. At that time you can discharge the contract. In some circumstances, the lapse of time may also discharge a contract. The periods of limitations for simple contracts is 3 years and the Under Limitations Act, and therefore on default by a debtor, if the creditor does not file a suit of recovery against him within 3 years of default, the debt becomes time barred and the creditor will not get the help of the law. This in effect discharge of contract, where times is of essence. If the contract is not performed on time, the contract comes to an end and the party not at fault need not perform his obligation and may sue the another party for damages. Yes, here lapse of time, what is the example? Just we looked into, yes, you are given, okay, credit, okay, you had given a credit to a person, he received, okay, so the agreement is for 3 years, okay, you had given some loan to a person, the agreement is for 3 years, within 3 years that person is supposed to return back the amount, okay, return back the debt. So before 3 years, if you file a case, then obviously you can find a solution. After the end of 3 years, okay, after the end of 3 years, if you go and file a case, you will not be having any rights because the agreement is already expired. The agreement is already lapsed. So the duration, for what duration you are going to create a contract, only for that duration the contract is valid. Once it is lapsed, then that contract will not be having any kind of capacities or any kind of value to go and sue a case against the opposite party. That is called lapse of time. Discharge by operation of law. So a contract is discharged by operation of law in the following cases. That is death. If any party is dead, okay, if any party dies, then they can discharge the contract because only one party cannot continue with the contract. There should be 2 parties. If any party dies, then the contract can be discharged. Next, insolvency. That means if any person fails to pay back, okay, if any person fails to pay back the debt, that person is called insolvent. So at that situation also we can discharge the contract between the parties. Next, merger of rights. Yes, if both the parties agreed to merge together, then at that time also whatever the contract is created earlier, that contract can be discharged. Next, loss of evidence of contract. So one party, what did it? It lost the evidences with respect to the contract. So at that time what they can do? They can discharge the contract. So in these situations you can discharge the contract by operation of law. Next, discharge by breach of contract. Yes, what is breach of contract? Breaking the rules is called breach of contract. So a contract is sometimes discharged, it is discharged by its breach. Generally, breach of contract means refused or future of any one party to perform its contractual obligation under the contract. Specifically, a breach of contract occurs when party to a contract does any of the following things. Yes, if any rules are breaked by any party, okay, if any contract rules are breaked by any party, at that time they can discharge the contract. So in what situations? The first one is fails or refuses to perform his obligations under the contract. So whatever the duties is supposed to perform under that particular contract, both the parties should perform the duty. If they fails to perform those duties, then obviously what will happen? The contract will come to an end and the contract will be discharged. Both the parties should perform their responsibilities. If any one party fails to fulfill their responsibility, then the contract will come to an end. Next, disable himself from performing as part of the contract. Yes, if he disable himself, if any party disable themselves from performing as part of the contract, that means if they fails to perform, again they can discharge their contract. Next, maker of performance of contract impossible by his own acts. Yes, if he fails to perform the conditions what and all is there in the particular contract, then again they can't continue in that particular contract. They have to discharge the contract because of breach of contract by the party. So with this, I'm going to wind up this session. I'll come up with few more topics in the upcoming sessions. Until then, thank you all. Have a nice day. Namaste.